I'm here today with a professional legal document assistant and licensed professional fiduciary to interview him on how to start the probate process in California. He's probated thousands of estates, so he would know. We get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary, as well as a registered and bonded California legal document assistant specializing in probate. I am also a licensed California real estate broker.
Now, please like and subscribe right now. Let us expedite your probate and save you time, money, and stress. Our team serves every county in California with our cost savings probate and real estate services. If you're selling property in California, you may qualify even if you've already started probate. Contact us. Our details are in the About section. We would love to hear from you. Bill, I always love talking to you about this because you have such a wealth of knowledge. But for our audience, let's get into how to start the probate process in California. I put down a number of questions for you today. I just want to ask you that I think will be of great value to our audience. Now, please, I'd like to introduce what probate is. Can you briefly explain what probate is and why it is required when a person passes away in California?
Sure. In a nutshell, probate is basically a court procedure that distributes the property of a deceased person to the heirs or beneficiaries of his estate. And the reason that it's done is because the person who passed away may have left property only in his name. Maybe a house, maybe a bank account, maybe an investment account. Because he's passed away, he can no longer sign anything to transfer the property to whoever he wants to. That's why the court has to step in. And you go through this process called probate, where the court basically, there's a person who becomes in charge of the estate appointed by the court, and then they now have the power to transfer the property to the rightful heirs or beneficiaries once the probate process has been completed.
So how does probate apply when real estate is involved?
Sure. Currently, and this is going to change a little while this year around April, but currently, if someone dies and they own real estate and the real estate is just in their name only and it's worth $185,500 or more, the law says you got to go through probate in order to transfer that real estate to the heirs or beneficiaries.
Yeah, got it. Now, how do you determine if probate is necessary for a particular estate?
Well, again, that's if you're over that $185,500 limit, you got to go through probate. And one thing I should just mention, kind of as a little caveat, some people will say, okay, well, my father passed away. He had a home that's worth $500,000, but he had a $400,000 mortgage on it. So it's only $100,000, so I shouldn't have to go through probate, right? Sorry. That $185,500 limit is based on the gross value of the estate or the property. It doesn't matter how much was owed, which is an unfortunate thing.
Yeah, right. And another thing that people think avoids probate is having a will.
Oh yes. Oh yes.
Yeah. So speaking of avoiding probate, are there situations where probate can be avoided?
Yeah, there most definitely are situations where you can avoid probate. There's a number of different ways. Owning a home in joint tenancy, and that's quite often where a husband and wife own their residence as joint tenants. And when one passes away, whoever the surviving joint tenant, property by operation of law, it automatically passes to them. There's nothing you need to do. So owning a home in joint tenancy is a way to avoid probate. Another way is a living trust. If you have a living trust at the time you pass away and your home is titled in the name of that trust, it won't have to go through probate. And there's another type of deed that you can do. It's called a transfer on death deed that you can set up before you pass away for a piece of real estate. But there's some caveats to that, and that's not always the best way to do it. The other thing about joint tenancy that you need to be careful about is, and again, this is not legal advice, this is just an opinion. I personally would never own a home in joint tenancy or a piece of real estate with someone other than my spouse. Because if I own a home with a friend in joint tenancy and that friend is involved in a legal action and gets sued, that house with my name on it, I could be dragged into some things that I might not want to be dragged into. So joint tenancy is not, there's some downsides to using that as to avoiding probate. You have to look into it.
Sounds like a trust is the best way.
I think so. I think a trust is the best way. Absolutely.
But what are the first legal steps that a family needs to take after a person passes away, specifically regarding the real estate sale?
Well, I would say the first thing is make a decision. Are we going to keep the house or are we going to sell it? That's the very first thing, is make that decision. If you're going to sell it as soon as possible, because selling the property as soon as possible, you're gonna have the least amount of taxes and fees and costs. So yeah, if the family has decided, yeah, we want to sell mom's house, get that probate started right away, get it on the market right away, and get it sold. Don't sit around and wait.
Now, who is responsible for initiating the process?
Well, if there's a will, normally it's the executor named in the will to get the process started. But if there's no will, really any family member, especially if it's a child, can initiate the process.
Now, before getting through the process, what should be considered regarding who should handle the probate, being the probate professional, whether it's a legal document assistant like yourself, attorney, or pro per?
Yeah. Well, you just name the 3 different ways you can probate an estate. Do it yourself, hire a non-attorney such as myself, or hire an attorney. But, essentially you want to make that decision. Doing it yourself, the advantages up front, it's going to cost you the least amount of money, but in the back end, you may end up spending a lot more than you think. Using someone like myself, a non-attorney legal document assistant, can usually save you quite a bit of money versus an attorney. So yeah, you need to make that decision.
Now, the next part, I suppose, would be actually starting the process. And there'd be the petition for probate.
Right.
What's some of the information that needs to be included in that
Sure.
when real estate is part of the estate?
Yeah, absolutely. Well, when real estate is part of the estate, obviously there's parts on the petition where you're going to have to list the address of the property. The court also wants you to give a rough estimate of the value of the property. Court also wants to know how much is owed on the property, and so they want to know the net value of the property. Now, when you need to get an estimate of the value of the property, that's where calling a good realtor, especially one like yourself that knows probate, can help you out there, can give you what the current market value of that property is. So yeah, absolutely. There's other things on the petition that need to go on there. I think it would take a long time for me to go through every single one, and maybe in a video we'll do that at some point.
Yeah, I didn't want to go through that. There's a whole different video.
Yeah.
And getting back to what you just said about who you should hire, and you mentioned pro per, which is doing it yourself. Then getting to the petition, there's parts on that petition we've talked about in other videos before where it seems like it could be simple to fill out, but
yeah, there's a lot of questions on the petition that the court asks and wants answers to that I would say, and I don't mean any insults to anybody when I say this, but to the average layman out there, person who's never dealt with probate before, you're more than likely going to incorrectly answer those questions, and then the court's going to ask for corrections, and they won't tell you how to correct it. They'll just say correct it, and it will lead to delays. It will.
Yeah, it could be significant delays, right?
Absolutely.
In months?
Oh yeah. Let's put it this way. I know of a client who came to me recently who had 2 errors on their petition, and they weren't able to get them corrected by the hearing date. So the court pushed it out 6 months for the next hearing date.
Yeah, that's a big delay.
Yes.
So hiring them the right professional would have saved them 6 months of
That's
holding
right.
costs
That's right.
and everything that's involved in real estate. Now, I believe you mentioned two terms there, and they're somewhat synonymous: administrator and executor.
Sure.
What's the difference?
Yeah, really, in the big picture of probate, they're really not different. It's a semantics thing. You're an administrator of the estate if there was no will. You're an executor of an estate if there was a will and you were the named executor in the will. And that's basically the difference. Everything else is the same.
So how is an executor or administrator appointed as the personal representative, person who can handle all the affairs of the estate?
It's the same. Basically, you file the initial petition, and at the time you file the petition, the court will issue you a hearing date. Between the time you file the petition and the hearing date, there's a whole bunch of other paperwork and things that need to get done. As long as all those things are done and done correctly, at that first hearing date, court will issue you what are called your letters, either letters of administration if you're an administrator, or letters testamentary if you're an executor. And it's a single-page document. And that document is your official court appointment, that you are in charge legally of the estate at that point.
Yeah, you really can't do anything until you get that.
Yeah, you have no authority to really do anything until you get those letters issued from the court. You're right.
Now, let's talk about responsibilities of that personal representative, the executor or administrator.
Sure.
Once the court appoints the personal representative, what must that person do?
Yeah, a lot. Basically, the administrator or executor, once appointed, you have a lot to do. You have to basically gather up all of the assets of the estate that existed at the time the person passed. You have to get what's called an inventory and appraisal done for all those assets, get values as of the date of death. If there's money coming into the estate, you have to make sure you put that into a special estate account, and you are responsible to make sure that none of that money is distributed or spent on anything other than legitimate estate expenses. And a lot of people who try to do it in pro per, this is where they mess up. I actually have had a few clients in the past who've come to me who are pro pers, and they've basically struggled, but they've gotten to the point where they want to file the final petition to close. And they've already distributed out all the money to heirs, friends of the heirs, people who shouldn't have gotten money. And they're in trouble with the court at that point, because in this one particular case, the court came back and said, you have to pay back all of the money that you distributed plus interest. So you want somebody who's going to be in charge of the estate that is financially responsible, financially educated, and someone who is highly, highly ethical. You don't want to just put anyone in charge of an estate.
Now, you can choose somebody who is not a member of the estate. Is that correct?
You absolutely can. And that's really what my professional fiduciary license is for. I'm the administrator for many, many, many estates because of the fact that I am a licensed professional fiduciary. And so it's my job to make sure that an estate is probated in a, I'll say, financially fiduciary responsible manner. That's what my license is for. And I do quite a bit of that.
Yeah, and you're held to a higher standard, wouldn't you say?
Oh, you bet. I can get into a lot of trouble as well as lose my license if I don't do things exactly by the book.
So if there's a family going through the probate process and they're thinking, we don't want anyone in our family to be the administrator, can they hire you?
Absolutely, absolutely. And what the nice thing is about what I do is, in situations like that where a family says to me, hey, will you be the administrator? I said, sure. And I don't charge any extra fee for doing that in the cases that I probate. So, it can be a real advantage for some families.
Yeah, I know from my experience where I've sold probate homes and you were the administrator, such a smooth process because the communication is more streamlined.
Right.
You know exactly what to do. I'm not having to explain all the intricacies of everything. It just goes so quick and smooth. I think what heirs and beneficiaries might have an objection to is maybe a misconception that they think that they're no longer decision makers or are not involved.
Yeah.
So how involved, even when you're the administrator in a probate real estate sale, are the heirs and beneficiaries?
Well, I keep the lines of communication wide open between the family when I'm acting as the administrator. And whenever offers come in on the probate real estate, I always discuss them with the family. And I say, look, even though I'm the administrator and I'm the one who's going to sign here, I want to make sure that you guys are all on the same page and this is okay with you. And so, yeah, I totally transparent and open with the family. And I have to be, because that's what my license says I have to do. So yeah, absolutely.
Plus, are they not? They must be given notice.
Absolutely, they are. Oh yes, all of the heirs will get, and we've mentioned this in several other videos, what's called a notice of proposed action. And basically that's just some documentation that describes the sale, the sales price, the terms of the sale. And it's all transparent. They all get to look at it, review it, and if they have any other questions, I will answer for them.
Now, we've discussed what probate is and determining the need for probate,
Right.
the first steps after the death of the decedent. The filing of the probate petition is the next step after that, and appointing the executor administrator.
Correct.
The responsibilities of that personal representative. Now we've progressed through. We're going through the probate process. The petition is done. The executor or administrator has been appointed. How much of the process has been completed?
Oh my gosh. Well, believe it or not, at that point, you're probably 40% of the way there. Yeah, there's still a heck of a lot that needs to be done after that.
Yeah, and how difficult is it to get to the point of where we just got to, the petition and the personal representative appointed, compared to the rest of the process?
Yeah. You've basically gotten through the easiest part. The hardest part is to come. The most difficult part for really anybody, and even attorneys, is the final petition and the formal accounting of the estate. A lot of the documents that you will file in a probate case are on what are called judicial counsel forms. They're basically forms with questions that you have to check boxes and answer, etc. However, the final petition and the accounting, there's no such form. It is completely drawn up from scratch. And there's certain items that you must cover in that final petition. And you also have to do a final formal accounting, unless all the heirs want to waive it. But in the estates I do, where I'm the administrator, I always do an accounting, because I feel it's just better for the family to see that. And a probate accounting is far, far different than a regular accounting. It's much, much different. And I can assure you that especially if you're pro per, if you're doing it yourself, you'll throw your hands up in the air and just pull your hair out trying to do a probate accounting. It's very different and quite complicated.
So even though you said you're about 40% in, the difficulty, you've done about 10% of the difficulty.
I would say that, yeah. I would say you're right.
Yeah.
That's a good analogy. Yeah.
Yeah, so you may want to consider who you hire, and you can hire somebody once you even start the probate process on your own. You can hire somebody later on.
Mm-hmm.
We've seen that.
Do that all the time. I have many, many, many clients who started on their own, realized that, man, this is a little too much. They give me a call, and I finish the probate for them. Sure.
Well, great, Bill. Thanks for answering all my questions. I think that helps you start the probate process in California. If you have any questions for us, want us to probate your estate, look at your house to sell, we're connected with realtors in every county in California who know probate and build probate estates in every single county himself. So please give us a call. Our info is on the channel, and please remember to like and subscribe. Now I'm going to link a video next that continues with the rest of the probate process. It's really the California real estate sales process explained in 5 minutes. It discusses real estate sales or probate sale in California in that amount of time, or actually less. Link next.